Hi, I'll be reading some techniques, not just some, but a lot of techniques in answering bar questions by Atty.Rey Tatad Jr. And this was actually first posted in 2018 in a Facebook page. So, according to him, when you want to give reason or reasons behind the law, you can use the following. The purpose of the law is blank. The law is designed to blank. It is intended to shield blank. It is primarily aimed at protecting blank from unwarranted blank. The rationale behind the law is blank. The spirit of the law is to the effect that blank. Now, if you are defining or you want to give a definition or an explanation, you can use the following. Blank is a comprehensive term used to describe blank. Blank, in its generally accepted sense, refers to blank. Or blank, it is a safeguard and guarantee provided by the 1987 Constitution. Blank, it is a kind of relief granted to a blank by the blank. Blank is a branch of public law or private law which deals with blank. You can also start with it pertains to. It connotes a. Blank is a doctrine in, example, civil law, which refers to blank. Or it is a principle in, example, criminal law, which states that. It presupposes blank. Its principal identifying feature is blank. It is akin to blank, the function of which is to blank. And he said that if you are giving an enumeration type of answer, you can use the following. In capsule form, the following are the elements of the crime of blank. In a nutshell, the following are the elements of the crime of blank. The following elements are generally considered in the determination of the presence of, example, let's say, employer-employee relationship. Next, you can say among the defenses or remedies available to, like Mr. X, as provided for by in the Constitution, are blank, blank, blank. The following are the requisites for, in order that a case for, let's say, BP 22 to prosper, the following elements must be attendant or present. Next, you can say, to establish a person's culpability under, example, estafa, it is indispensable that blank, blank, blank. Or to constitute, let's say, homicide or murder, the following requisites must concur. He said that if you can enumerate all, write it in bulleted or numbered form to highlight the fact that you know all of them. And for more convenient reading purposes, if you cannot enumerate all, write it in paragraph form so that it would not easily be noticeable that you missed something. Next is distinction. When being asked to distinguish, do not state its definition. If you give its definition, you are in effect asking the examiner to extract out the differences of the two or more from your definition. Do not also give their similarities. You are asked to differentiate and contrast. So similarities are not included. That was a tip he learned from his professor in civil law review, Attorney Virgilio Gesmundo. The number of distinctions you will give must also be proportionate on the points allotted for such. If it is only worth 2 points, do not give 8 distinctions. The examiner cannot give you 8 points for that. For a 2-point distinction question, perhaps 3 would be enough. 4 is too much then. Example, the two may be distinguished from each other in the following ways. Another, in the first, it is necessary that there be blank, whereas in the second, it is sufficient that there be blank. Or you say in the former, blank, while in the latter, blank. Or you can say the former requires blank, while the latter, blank. Now, in answering questions with vague facts or which requires qualification, but if the facts are complete in itself, do not attempt to add facts or assume anything. He said we can use the following. We must distinguish if blank, like or as far as the blank is concerned. Or it depends if blank, or as far as the blank is concerned. The question requires a qualified answer if. I will qualify if on the assumption that my answer must be qualified. Now, when answering about jurisdiction, we can use the case is beyond the ambit of the jurisdiction of the regional trial court. It is within the ambit of the blank or Secretary of Labor's power. It is not within the province of the municipal trial court. It is clearly within the powers of the example labor arbiter. The case of blank is cognizable in blank. The case of blank lies with the municipal trial court. The case is covered by the rules on summary procedure, or the law vests upon the Secretary of Justice the power to blank. Now, when elaborating or expounding answers, we go straight to the point. The length of answers and expounding the same must always be proportionate to the points allotted for such particular question. The higher the points, the more in-depth the elaboration should be. However, it must not appear that we are going around the bush. If your answer is too long, it is an indication that you are not sure of the answer, so there is that need of getting around the bush. Remember that most of the times, more talk, more mistakes. And he got this trip from his professor in political law. And these are the examples that you can start your answers with. It should be borne in mind that blank. It must be noted that blank. It must be recalled that blank. It is worth observing blank. It must be taken into consideration that blank. More importantly, blank. Significantly, corollarily, furthermore, moreover, similarly, parenthetically, in other words, otherwise stated, simply put, simply stated, or stated more concretely. The reasons are obvious. The reasons are well known. The reasons are plain. This is for expounding answers under the same line of reasoning, or as regards, with regards to. It is an error to state with regards to. So we regard to. And then the first issue, as far as the blank is concerned, this is indicated by the fact that blank, the language of the law leaves no room for that blank. Justice and fair play dictates that, I like this, applying the principle of blank. The law is categorical with regard to blank, notwithstanding the blank. It is beyond debate that blank. It is imperative to look at blank. This is consistent with the time-honored maxim, blank. As it is imbued with public interest, blank, I like that too. In like manner, in the same manner, in the same vein, in the same breath, likewise, in fine, it bears articulating that the controlling element in the blank is, by analogy, blank. Emphasis must also be placed at blank. Manifestly, there was blank. Example, manifestly, there was grave abuse of discretion amounting to lack or excess of jurisdiction. Needless to stress that blank, it goes without saying that blank, the Supreme Court frowns upon the example, illegal practice of form shopping as it erodes the administration of justice and makes a mockery of the justice system. Or there is no denying in this case that, example, the petitioner never raised the issue of jurisdiction throughout the entire proceedings in the trial court. So, accordingly, these are tips that can be remembered when quoting the Supreme Court, citing a piece of jurisprudence, or mentioning a principle, doctrine, or theory during the bar examination or during the law examinations. We can say the Supreme Court in one case had the occasion to rule that blank. In a long line of cases decided by the Supreme Court, it has always been consistently held that blank. In a litany of cases decided by the Supreme Court, it has been decreed that blank. In a long string of cases described by the highest court of the land, blank, blank, blank. According to several cases decided by the Supreme Court, blank. In a series of cases decided by the Supreme Court, blank. So note, we do not use the words series, litany, or long line if there is only one decision or piece of jurisprudence for that topic from the same lawyer. Another one, in one case decided by the highest court of the land, it was held that blank. Next, in one case, the Supreme Court ruled that blank. It has been said that blank. In a recent case, the Supreme Court has laid to rest the issue of whether or not blank. It is well settled in this jurisdiction that blank. It is well settled in this country that blank. The Supreme Court has steadfastly adhered to the doctrine which states that blank. In the case with similar facts, the Supreme Court ruled that blank. In several notable Supreme Court decisions, the highest court declared that blank. The Supreme Court has often stressed that blank. In the landmark case of AAA versus BBB, the Supreme Court laid down the doctrine which substantially provides that blank, blank, blank. He also said that it's better to cite very famous cases only. Like in the leading case of blank versus blank, as enunciated by the Supreme Court in one case, blank, the court has repeatedly ruled that blank. A case in point in blank versus blank where the Supreme Court held that blank. And those are to replace the phrase already decided by no other than the highest court of the land, which according to project jurisprudence takes up too much space and sounds corny. And so we are better off by using, there is likewise an array of cases in this jurisdiction where the Supreme Court has consistently declared that blank, deeply rooted in the jurisprudence which provides that blank. In one case, the Supreme Court was emphatic when it ruled that blank. It is Hornbook doctrine in, example, civil law, that blank. Other examples, immortal is the rule that blank, well settled is the rule that blank, well entrenched is the principle that blank, elementary is the rule that blank, the cardinal rule in, example, labor law is that blank. It is a familiar canon in, let's say, political law, that blank. In labor law, it is well settled that blank. Basic is the rule in, example, criminal law, that blank. It is an elementary principle. It is a fundamental doctrine. Well accepted is the rule that blank. Or it is axiomatic in, let's say, civil law, that blank. Enshrined in the 1987 Constitution is the rule that blank. In consonance with the rule that blank, or the rule in civil law that blank, it is a recognized doctrine in civil law that blank. It is a basic tenet in commercial law that blank. Consistent with current jurisprudence, blank. It is a legal presumption born of wisdom and experience that official duty has been regularly performed, etc. Or the Philippines adheres to the principle of blank. He also said that in his personal opinion, it is not proper to use the statement in the case bench or in the case bar when answering. Wow, I've been using this. Although it is very tempting because it sounds good and professional to state. He gave the reason that the cases given in the bar are only theoretical. The statements in the case at bench and in the case at bar are more appropriately used in pleadings in court. Therefore, it said that the most appropriate statements to use are in the instant case, in the facts given, in the problem given, and in the question presented. Therefore, we can use the following, applying the said law or doctrine in the instant case. From the facts given, noteworthy is the blank. From the facts of the case, it is readily observable that blank. In the instant case, it may be observed that blank. It is crystal clear from the facts presented that blank. In the present case, it is immediately noticeable that the element of blank is wanting or lacking. Under the circumstances, the proper remedy would be blank. The case obtaining indicates a case of blank. It logically follows that blank. It goes without saying blank, even assuming arguendo for the sake of argument that blank. The situation in the case at hand, blank. The situation presented evinces a case of blank. The facts sufficiently indicated blank. In the given facts, it is immediately apparent that blank. In the same token, it is evident that under the facts stated in the problem, in the case under consideration, worth stressing is the fact that, worth emphasizing is the fact that, or the facts would reveal that blank. A careful perusal of the facts of the case would reveal that blank. A careful scrutiny of the actuations of the accused would reveal that blank. A careful reading of the blank would reveal that blank. A cursory examination of the blank. Now, when answering in the positive, we can use the following. The petition is meritorious, period. The contention has legal basis. The case will prosper. The argument is proper. The provision is perfectly applicable. The action is tenable. The motion should be granted. The judge is correct. The petition is impressed with merit. Yes, it is. Blank of the. There is merit in the petition. The petitioner's contention is sustainable. When answering in the negative, the contention does not hold water. With all due respect to the judge, his decision is apparently erroneous or is not in accord with law and existing jurisprudence. The contention is totally misplaced. It is now too late in the day to raise the issue of blank. The petition is not meritorious, period. The evidence presented deserves scant consideration. The contention has no legal basis. The argument is bereft of merit. The petition is devoid of merit. Petitioner's reliance on the blank is inappropriate. The doctrine of blank does not apply in cases where blank. It is a futile gesture on the part of the respondent to invoke the rule on blank. The theory or argument has no ground to stand upon. The contention has no leg with which to stand on. The position of the petitioner runs counter with the doctrine of blank. The case will not prosper. The case is not tenable. The act of the accused in blank is of no moment. The assertion lacks substance. The decision is erroneous. The court cannot countenance the blank. The testimony that blank cannot be given credence. The evidence presented has no probative value. The allegation is belied by the fact that To put it otherwise would be to render the law on blank useless or futile. The actuations of the accused in blank negates blank. While it is true that blank, it is guaranteed right of a person, it does not, however, mean blank. It is not correct to say that. It is not proper to state that. It is not accurate to conclude outright that blank. A contrary conclusion would erode the rule that provides in part that blank. To sustain the contention would be to render the law on a blank nugatory. It would be absurd and incongruous to sustain the argument that blank. It is not enough that blank. The fact that blank is immaterial since blank. The fact that blank is irrelevant since blank. In itself, mere blank is not sufficient to, let's say, warrant conviction. The petitioner cannot give any additional meaning to the clear and plain language of the law. The Supreme Court, in several cases, has struck down the blank. The attendant circumstances of the case are contrary to the petitioner's assertion. The evidence does not support the theory of the petitioners. There is no cogent reason to disturb the ruling of the blank. The claim for blank must necessarily fail. The blank cannot rely on blank to aid his cause. Concluding words would be the following. From the gamut of evidence on hand, it can be gathered or deduced that blank. Taken all together, blank. Finally, hence, therefore, from the foregoing, it can be deduced that there is really a blank. From the foregoing, it is now safe to conclude that blank. Lastly, consequently, as a necessary consequence, the logical implication is that, at any rate, in view of the foregoing, as an inevitable conclusion, in the light of the circumstances, undoubtedly, indubitably, clearly the case at hand falls squarely within the purview of blank. Verily, he or she has committed blank. For this or these reasons, it is unavoidable to conclude that, based on the facts obtaining in this light, this being the case, clearly, therefore, applying the aforesaid ruling in the case of blank, or in the case at hand, in light of the foregoing, it is beyond cavil or doubt that there is no doubt that blank. To the unprejudiced mind, the actuations of the three, when analyzed and taken together, leads to no other conclusion except that blank. Inescapably, therefore, all things considered, it follows therefore that, as a logical result, in sum, in view of the fact that blank, all told, given the prevailing facts, having stated the foregoing premises, on final point, accordingly, or ergo, and that's the end of his suggestions. Now I have to read his disclaimer. He said this is only a guide material and will not and cannot assure anyone of passing or even topping the bar. What is assured only is that it will greatly facilitate the candidate's presentation of his or her answers. And if you learned something from this, you can go ahead and share and give us a thumbs up. If not, a thumbs down. Don't forget to subscribe. Thanks.